What's up, everybody? It's Peter Tragos, the lawyer you know, and on this channel, we break down the trials and cases you care most about so you can understand how the American civil and criminal justice system works. And we try to make sure you understand what your rights are in every situation, which is why we try to walk you through the entire legal process while also answering your insightful questions along the way. And while it's not legal advice, it's always exciting. So buckle up for another episode of The Lawyer You Know. What's up, everybody? Wanted to come in and do a video to update you on what's going on with Sarah Boone, the suitcase murder trial, because it is one that we have been following. We've been breaking down some of the interrogation videos, a lot of the statements made by the defendant in this case. But something that has been an overarching theme throughout the entirety of this criminal investigation and litigation has been the number of lawyers that are coming on and off the case. And I believe we are on number 6 right now currently that was appointed by the court in July, and he has just filed a motion, and we're going to get to that today and more and talk about how that may affect the case and whether or not the judge will even let him get off the case and how that could affect the potential appeal. So hit that like button if you haven't already and subscribe to our page if you're interested in this case. This is not live, but I will try to be in the chat, as always, talking to you guys about this. So without further ado, let's get to the motion filed by Sarah Boone's current attorney. Dadgum tagged me on this on Twitter at Tragos Law. If you want to follow me on Instagram at Tragos Law and send me stuff like this that we can break down. This is a motion to withdraw as counsel. Comes now Frank Bankowitz, counsel for the defendant in the above styled case, and hereby requests that this court enter an order permitting court-appointed counsel to withdraw from this case and from further representation of the defendant. Permitting. You can't just bounce if you want to, especially this close to trial. It's December 20th. He's filed this on December 19th. You're probably watching this on the 21st. The trial is January 30th. So barely more than a month for a murder trial. You're trying to get out. Usually, courts will not allow you to bail on a criminal defendant in these circumstances this close to trial. So it's not a guarantee that this lawyer is out. Now, he was appointed on July 11th, 2022. So he's barely been on the case 4 months. He was appointed by the court. So he's a private lawyer, and I looked him up. He's been barred since 1974. So plenty of experience there. That's not an issue. What's the reason? Due to irreconcilable differences which have arisen between the undersigned and his client and his family. The undersigned, his client, and his family. The undersigned will be unable to effectively and properly continue representing the defendant herein. So it depends on the reason, right? If he doesn't like his client or they can't come to an agreement or she's causing trouble, the judge may force them to stay together and continue to go forward towards that January 30th trial date. If he's saying there's some kind of conflict with his family, meaning he can't appear on January 30th, or there's a death in the family or a sickness or something happened that he can't do it, then he's going to be off the case. No doubt about that. But if it's just they don't like each other or they can't come to an agreement on defense, the judge is going to have to say at some point, Ms. Boone, you've got to get a lawyer to go to trial with you or represent yourself or whatever you want to do. We got to get this case to trial. You can't keep delaying it by getting rid of lawyers. And she has done this not 1, 2, 3, 4, 5, but 6 times. And this is a court-appointed lawyer, not lawyers that she's hiring, which are more difficult to get rid of when you get it appointed by the court. You can hire and fire lawyers kind of as often as you want under reasonable circumstances, but you can't use it to continue to delay the case because the victims deserve justice in this case. So this is another piece in a wild ride. But I will say, if this motion is granted, you can all but guarantee this trial is not happening on January 30th, 2023. There will be yet another delay. If a new defense counsel needs to be appointed in this case, he or she will have to have the opportunity to prepare this case, talk to Ms. Boone, prepare a defense, and get ready to go to trial. If the judge denies this motion, it will absolutely be point number 1 on appeal. Whatever's going on in the background to create these irreconcilable differences, Sarah Boone and her appellate attorney will say, this is the reason she lost. This is the reason she needs a new trial. He was ineffective counsel. It's an ineffective assistance of counsel claim. There were issues. We tried to put the court on notice. The court ignored it. and the court allowed the trial to go forward. And I will say that argument has been made many times. Sometimes it works, many times it doesn't. Just because a judge denies a motion to withdraw does not automatically mean that if a criminal defendant's going to win on appeal, obviously, or a judge wouldn't do it. Now, many times when private defense counsel tries to file a motion like this and it's based on Mr. Green or some of the arguments we heard in movies like Lincoln Lawyer, the client didn't pay. Well, a judge will deny that one if it's this close to trial, not allowing a private criminal defense lawyer to bail on their client before trial, forcing them to go to trial. And again, there could be major differences, but the judge isn't going to screw the defendant because they didn't make a payment to the criminal defense attorney. Some could say it screws the criminal defense attorney because he's not getting paid for the work that he or she is doing. But that's the justice system, and we can't leave people out to dry. We also can't delay justice for the victims over and over again because the criminal defendant can't work with any attorneys. So this case continues to be wild. Each criminal defense attorney has said it's a tragic situation, but not a crime. We will see if that's what they go with. Accidental death, no intent. My guess is that's the defense in this case, but you guys sent it to me, so I wanted to answer your question. Let me know in the comments if you have any other questions, and hit that like button on your way out.